Good morning and good afternoon to everybody who's joined us today, and a very warm welcome to our webinar on the implications of the Eco Oro Decision for investment treaty negotiations and reforms. My name is Nyagode Maina, an international law advisor with IISD. The overview of our session today will be as follows. We will begin with opening remarks by my colleague, Dr. Susie Nikema, who's the lead of the Sustainable Investment Workstream at IISD. She will also introduce us to the esteemed panelists joining us today. We will then have the first round of panel discussions, which sets the scene and aims to help us all better understand the decision. We will then have a 15-minute Q&A after that session. Then we will have an IISD presentation of data on public interest exceptions in investment agreements. This will be followed by a second round of panel discussions, looking at the decision's implications for treaty reform. There will also be an additional 15-minute Q&A after this second panel. And thereafter, we'll have some closing remarks. I'd like to now hand over to Dr. Susie Nikema, who will introduce the webinar and introduce us to our esteemed panelists for today. Over to you, Susie.
Thank you very much, Nyaguti. Good afternoon or good morning, as the case may be, to all the participants joining us from around the world to discuss the recent decision in Eco Oro versus Colombia. Every so often in the ISDS regime, a tribunal makes a decision, one that is so problematic, so contrary to the public interest of states and their citizens, and so fundamentally wrong that it reverberates around the international investment law community and beyond. These type of decisions usually serve to illustrate the novel and unexpected ways that arbitral tribunals could interpret or misinterpret the language of investment treaties. They usually spark concerns and often spawn new treaty language, while once again underscoring the fact that the current regime is not working and is in need of systemic reform. Eco Oro versus Colombia is one such decision. But unlike of many of these previous red flag decisions, which have illustrated the problems with old-style treaty language and aspiring reforms, Eco Oro has been all the more concerning because of its implications for modern treaty exceptions, which were spurred by overly expensive and problematic arbitral interpretations of the old-style language in the first place. Carving out interest objectives in investment policy is crucial for government to ensure that they can take measures to protect the environment, local communities, natural resources, and biodiversity. This is all the more critical in light of the climate crisis. This decision has shown that even with modern treaty language expressly designed to protect these interests, government are still at risk from legal challenges as they try to learn from the past and pursue more balanced investment policy frameworks and sustainability objectives. The International Institute for Sustainable Development has been a pioneer in raising awareness on the need to revise investment treaty language to include public interest exceptions. We did so by proposing the first ever new model international agreement on investment for sustainable development in 2005. At the same time, we have also alerted governments that simply importing GATT-style general exception style language coming from a different system won't necessarily prevent them from paying compensation in treaty-based ISDS system. Our discussion today will examine the implications of this decision while focusing on the perspective of country investment treaty negotiators, particularly developing countries. Our esteemed panelists at this event, who I will introduce in a moment, will explain what was decided in this case, which type of treaty provision are affected. They will draw out some of the implications of this decision for the existing stock of old-style treaties, as well as for newer model treaties and their recent updates. They will also explore how this decision can inform countries' strategies in defending ISDS claims. Ultimately, we'll aim to unpack what lessons could be drawn from this decision in the context of current global reform processes for the international investment policy regime. So today we have a dynamic panel who will help us unpack the nuances of the cases. And each speaker has a wealth of experience and in-depth understanding of treaty-based investor-state dispute settlement, and each from a different and complementary perspective. Ben Dunheath, he's an assistant professor at Temple University, Beasley School of Law, who has widely published on the international investment regime, and he will enrich our discussion from an academic perspective. Thank you for joining us today, Ben. Simon Batifor is a partner at Curtis Mallet Prevost Colt and Mossel LLP, where he has vast experience defending exclusively states in investor-state investment arbitration. He will enrich our discussion from a practitioner's perspective. Thank you for joining us today also, Simon. We will also have the pleasure to listen to a short presentation by my two colleagues, Nyaguchi Maina, International Law Advisor, and Lucas Schaut, International Economic Law Fellow at IIAs, on some useful data and key consideration to feed our discussions. While the discussions are going on, please feel free to share comments and questions on the chat, and we will do our best to address them. Given the time and the number of participants, we won't be able probably to allow for oral intervention. So please make the best use of the chat during the panel discussion. So let's start with the first round of discussion to set the scene and try to understand better the decision. And my first question will go to Ben. So to ensure everyone is on the same page, particularly those who haven't had a chance to read the all long and complex decision, and we have seen from the poll that most of you are in this situation. Can you take us through the main point of the decision and explain briefly the key fact of the underlying dispute, which type of treaty provision have been invoked and discussed, the kind of treaty exceptions that were discussed, and the reasoning on the tribunal specifically on such exceptions, and what was decided by the tribunal? Thank you.
Great, and thank you so much for having me. And I see so many names in the list of participants, people I know and people I would be excited to meet and talk with afterwards. So thank you so much. My comments here, given our time, are going to be necessarily stylized. And I'm going to try to get us to focusing on the exceptions provisions and the implications systemically of this case, because I think that's what we have time to do. So this is a case that was brought by a Canadian mining company, formerly known as Greystar, now Eco Oro, against the Republic of Colombia. Greystar sought to exploit deposits of gold, silver, and other metals in the Soto Norte region of Colombia. These deposits overlap to some degree, and it's contested how much, with an environmentally sensitive area that's referred to in the decision as the Páramo de Santurban. And a páramo is essentially a high altitude wetland. These are essential parts of the water cycle, contributing to the provision of fresh water. They're also valuable as carbon sinks in a time of climate change. Eco Oro had a concession contract with a Colombian state entity, and it had a right to explore the relevant area. The contract also contemplated a right to exploit these minerals on the condition that Eco Oro obtained various legal approvals, including, for example, an environmental license. As Eco Oro is gearing up for this project and gathering momentum, the Colombian authorities and the Colombian state is sort of engaged in an ongoing process and struggle and negotiation domestically over how to balance two key imperatives in this area. On the one hand is the perceived need to foster investment in the mining sector with all the development, money, and jobs and infrastructure that might bring. And on the other hand is environmental protection and conservation. And there are domestic constituencies, and you only get this orthogonally in the decision, but there are domestic constituencies ranged on all sides of this issue: local and national officials, city government, regional government, conservation advocates, mine workers, city residents who are concerned about clean water, and so on and so forth down the line. And the government is caught up in this struggle, which has involved all three branches of government acting and governing and trying to move forward, including the courts and multiple administrative agencies, environmental regulators, mining regulators, and so forth. And as a result of all of this, quite naturally, in a time of sort of political rebalancing, the investor is getting conflicting signals about the long-term viability of this project. And at the center of this conflict was a long-running attempt to draw borders around these wetlands, the Páramo de Santurban and other wetlands in the country. There's an ongoing effort to demarcate these areas, but it's taking a long time. It's bogged down by significant technical limitations, the scale and difficulty of the project, and by arguments that the state has failed to engage in the necessary consultations in this region with affected citizens, including mine workers and so forth. So in short, what you have is a country that's struggling to balance all these competing values of investment promotion and environmental protection. And this was a matter of domestic politics. There are bona fide interests on both sides, a divided government trying to arbitrate between competing values. At no time in this decision, and this is one of the things that makes Eco Oro relatively singular here, there's no allegation the investor here is targeted. There's no discrimination being alleged, and everyone in the tribunal agrees that it's not happening. This is not an attack on foreign investment. Domestic investors are caught up in this as well. This is an effort to govern. So in 2016, Eco Oro decided essentially that it had had enough and initiated arbitration under the Canada-Colombia FTA, the free trade agreement. This is alleging expropriation and breach of the standard of treatment. This is one of these multi-chapter trade agreements where investment constitutes one part. For our purposes, the tribunal makes 4 key rulings. So first, it decided by a 2-to-1 majority that the state's measures did not amount to an indirect expropriation, citing police powers doctrine as reflected in the treaty's annex on expropriation. These have become rather common. In this respect, the tribunal found the state's measures were non-discriminatory, pursued a genuine public welfare objective, were in good faith, and were designed to protect the environment. The mixed signals, the drawn-out process, and some of the outright process fouls and process failures that took place over the years did not amount to an expropriation, the tribunal says. Second, though, by a different 2-to-1 majority, so you have the claimant's appointed arbitrator moving to dissent or moving to the majority and the respondent's appointed arbitrator moving to dissent, you have a finding that the same measures breach the international law minimum standard of treatment by virtue of the state's inconsistency and its failure to provide a stable business framework or stable business environment. The tribunal described the situation of instability as one of, quote, arbitrary vacillation and inaction that led to the claimant being unable to exploit their interests. Third, the tribunal turned very briefly to the general exception in Article 2201, paragraph 3 of this agreement. This provision is modeled largely after GATT Article 20. So it provides that nothing in this chapter shall preclude a state's ability to take measures necessary for, among other things, the protection of the environment, so long as those measures aren't arbitrarily discriminatory or a disguised restriction on trade, so forth. The tribunal, through some convoluted reasoning, and this is something I've spoken about publicly before, appeared to argue that this provision did not affect Colombia's responsibility to pay compensation. So even if the provision were engaged, Colombia would still have to pay. But fourth, and this is important just to keep in mind, despite having had full briefing on damages, the tribunal has held off its decision on damages to another phase, asking more questions of the parties, and so there's still a possibility that damages could be rather low or even zero in the next phase, although it's also possible that they could be quite significant.
Thank you very much, Ben, for this great summary. And given that the decision was quite long and complex, we really appreciate you providing us the key point and explaining what were the underlying issues. Thank you so much. I would like now to turn to Simon for my next question. According to a recent analysis by Wolfgang Alschner from University of Ottawa, this decision, and I quote him, reproduce the reasoning of past awards rendered under agreements without exceptions, but state must still protect the environment while observing investment commitment. Based on your experience in representing states in investment arbitration, what do you think this comment says about the quality of arbitral decision making? And do you agree with him, actually?
Thank you, Susie. And likewise, I'd like to thank IISD for having me here. It's a pleasure. So I think what Professor Alschner is saying is that he sees the Eco Oro decision as an example of a tribunal effectively ignoring an express environmental exception. And I agree with that. Let's keep in mind here that the tribunal did not dispute that Colombia's environmental measures fell within the scope of the exception. Tribunal accepted that this was the case, but it nevertheless found that Colombia was liable to pay compensation. Potentially, if compensation is proven. Okay? Like Ben said, this is the object of the next phase, but in principle. So there are many aspects of the tribunal's reasoning on this point that are puzzling. And all of my sympathies go to the 14 or 15% of folks who have actually read apparently the entire decision, because it can be painful at times. So I'll just focus on three aspects that I find particularly puzzling on the tribunal's reasoning on this point. First, the tribunal relied on the fact that the exceptions clause did not expressly provide that the state could take environmental measures without the payment of compensation. But there was no need for the treaty to say that. In international law, you need to establish a breach of a treaty before you get into the question of the compensation for that breach. So if a state reserves the right to adopt environmental measures through an exceptions clause, it does not need to also say that no compensation will be due. That's the normal consequence under well-established principles of state responsibility. The second related point is that the tribunal actually agreed that the exceptions clause in the treaty meant that a state may adopt environmental measures without finding itself in breach of the treaty. You can see that, that's a quote from paragraph 830 of the decision. I read it too. In other words, the tribunal recognized that there could be no breach if the measures fell within the scope of the exception, which was the case. But then the tribunal went on to say that this did not mean that no compensation was payable. I don't understand that. Again, if there's no breach, the rules of international law and compensation for breach do not come into play. The third point I wanted to mention concerns the tribunal's reliance on the provisions of the ILC articles on state responsibility regarding the consequences of circumstances precluding wrongfulness. The ILC articles state that necessity and other customary international law defenses may preclude wrongfulness of state action, but that this is without prejudice to the question of compensation for any loss caused by that action. And the tribunal referred to that provision of the ILC articles. But Colombia was not invoking a customary international law defense. It was invoking an exceptions clause specifically provided in the treaty. This reminds me of tribunals in investment arbitrations against Argentina that equated essential security interest provisions with customary international law defenses. This approach has been thoroughly criticized, including by the ICSID ad hoc committees in CMS v. Argentina and Sempra v. Argentina, which underscored that such carve-outs prevent a finding of breach and therefore prevent an award of compensation. In Sempra, the tribunal actually annulled the award on that basis, saying that it amounted to a manifest excessive powers. So in short, yes, I agree that the Eco Oro decision is poorly reasoned. I have a hard time following its logic, and I think it misapplies basic principles of international law.
Thank you very much, Simon, for this really rich and illuminating explanation. And I think it's already explaining for those who are very new to this decision why it is so criticized.
Merci beaucoup, Simon, pour vos explications très intéressantes et éclaircissantes. Ma prochaine question va peut-être fournir davantage d'explications aux défis auxquels nous sommes confrontés suite à cette décision juridique. Je me tourne maintenant vers Ben. Vous avez dit que La clause d'exception environnementale en causant cette affaire est inspirée de l'article 20 du GATT. Comment a-t-elle été interprétée dans le contexte du règlement des différends commerciaux et pensez-vous que cette affaire soulève des questions plus larges sur l'opportunité d'une fertilisation croisée des concepts du droit commercial et du droit des investissements? Car les deux systèmes
Yes, thank you for that question. I think it's a really important question. And the short answer is that I have deeply held and long held reservations about the usefulness of including these kinds of exceptions provisions in investment treaties. And not because I don't support flexibility, I do. But I think that including this type of GATT-style language, by doing that, the states that have been doing this have been courting disaster for a long time. I wouldn't have predicted this particular disaster because who could? You can't follow the reasoning in the exceptions section at all. But there are real problems even if this case were fixed. And so I want to sort of say something about that. So as you said, this language is derived from the GATT. And these kinds of exceptions are familiar to a lot of folks who have taken a basic public international law or trade course. And they have essentially three components. First, the measure must pursue a legitimate aim. And often in these provisions, that's a closed list. And so here that's either environmental measures in subsection A or conservation in subsection C. There are others, human health and so forth. Second, the measure must be necessary to serve that aim. And there's sort of a disconnect between how that word has been read in some of the decisions and how it's been applied. And it's been applied somewhat loosely, but this usually entails in all factors very searching analysis, and it demands that the measure be the least restrictive means available to achieve the state's desired regulatory aim. Now, finally, the measure has to be consistent with what trade lawyers call the chapeau elements of the exception. The requirement that the measure not be arbitrarily discriminatory or a disguised restraint on trade, or in this case, on trade or investment. Rob House, for example, has argued that at this step, the appellate body at the WTO has engaged in a kind of what he calls close look review, scrutinizing the fine print of regulations in order to find loopholes or inconsistencies that make the regulatory regime arbitrary and arbitrarily discriminatory. And so I think already we can see why we might want to be uncomfortable importing these provisions into investment treaties. Number one, these exceptions use language that is stricter than what we should interpret the primary obligations to require. If I look back at a BIT from the bad old days, from 1990 or 1984, I don't see anything in your average investment treaty that says measures should be necessary to achieve a public aim. I don't see anything that says that measures should be the least restrictive means adopted. I don't see any closed list of regulatory aims that a state should pursue. Right. And so by bringing this in, even as an exception, we're sort of making several implications about the scope of an investment treaty that ought not be there, in my view. The second problem is that this kind of close look review that you see in the trade context becomes problematic in investment law. So in trade, environmental measures often fail this test, but the remedy is prospective. So the state is supposed to bring its measures into compliance. So if the WTO appellate body finds a discriminatory loophole in a regulatory regime, the state can fix the problem by closing the loophole, optimizing the regime, and making it stronger. And then it can actually defend that move in subsequent compliance proceedings and often win, right? So that can strengthen an environmental regime. In investment, the remedy is retrospective. So if a tribunal engages in the same kind of fine-grained analysis and finds a loophole it doesn't like, or some kind of strange little thing in the regulatory framework, then the exception doesn't apply and the state is on the hook for a money and damages award, right? For potentially hundreds of millions of dollars. So what you have here is a provision that looks like it adds flexibility, but it instead adds to an overall context saying that regulations must be strictly proportional, narrowly tailored, closely scrutinized, and if we find anything wrong, we're going to get you. And I don't think that's what we want this regime to be doing. So that's my short answer here. That doesn't respond to the Eco Oro problems because they're even worse, right? But even if we get past Eco Oro, we have these problems that are still with us.
Thank you so much, Ben. I think I'm hearing something important you have said, but importing a provision that was designed in a different context where it is based on compliance system to another system where it is more a litigation system with a compensation awarded at the end. It's really different system. So you cannot just import this kind of thing. And I think that's one example, but we'll also have other examples where just importing trade concept to investment law concept might be concerning. And I think countries it's important for them to keep it in mind also in the reform process. Thank you so much. So before we try to have a kind of discussion with the panelists, and I hope everyone has started to put some question and comment on the chat, and Lucas will help us review that in a few moments. I would like to ask a last question for this first round of discussion to Simon, because many commentators considered the Eco Oro decision to be significant for the fact that the tribunal interpretation of the environmental exception in question contradicted both the home and host state's intent, actually, of the treaty provision. So what does the decision say about the interpretative discretion of arbitrators, as well as the role of joint interpretive statement in the context of an investment arbitration? So when the home and the host state agree that this is what they had in mind when they put this exception, and then the tribunal just decide to have its own interpretation of the provision. What does it means for arbitration system in general?
Yeah, that's exactly right. And I think in this case, what's striking is you could argue that the contracting states have really deployed their best efforts to limit the scope of interpretive discretion of arbitrators on this issue. They've done so, of course, primarily through the exceptions clause itself, which expressly preserves the ability for the states to adopt measures for the protection of the environment. As Professor Sands said in his dissenting opinion, and I quote, "The FTA has evidently been drafted with care to ensure that measures properly taken to protect the respective environments of the two countries are not undermined by rights granted to foreign investors." But there are other ways in which the states have tried to confirm the limits of arbitrators' interpretive discretion on this issue. In 2017, a joint commission comprised of representatives of both states, Canada and Colombia, issued a decision in which they, quote, "reaffirmed the right of each party to regulate within its territory to achieve legitimate policy objectives, including protection of the environment." And then in the arbitration itself, Canada also filed a non-disputing party submission in which it made the essential point I mentioned before, that no compensation can be owed if the measures at issue fall within the scope of exceptions. Colombia made the same point, of course, in its submission in the arbitration. The Eco Oro Tribunal plowed through all of that evidence of the intent of both states in finding that compensation was owed, even though the exceptions clause precluded the finding of breach. I think you could say Eco Oro is a cautionary tale. Shows that no matter how diligent the contracting states to an investment treaty may be in clarifying their common intent, there's always a risk that a tribunal will ignore that intent.
Thank you very much. And I think this will be a nice introduction to the second part of our discussion after the Q&A, because we will try to understand in terms of implication to what extent countries putting it forth on reform and revising the investment treaty can really rely on this kind of new language to prevent them from this kind of interpretation. But I would like now to have the opportunity to share views and comment and questions with the speakers from the participants joining us today. And I would like to turn over to Lucas to let us know if what is going on the chat and if we got a lot of comments and questions.
Yeah, so far we have received 2 comments and 1 question in Spanish and 2 comments in English. So feel free to please post your further questions or comments on the chat. And I will start with the 2 comments and then ask the question for our two panelists. So first comment from Sanya Reed-Smith refers to a study of 2015, which found that 44 attempts to use the general exception, the GATT-style exception, governments only seem to have succeeded once in doing that. So that seems to be pointing to the fact that those, I don't know, there must be an underlying problem related to those exceptions. I can also see that there is a second comment by Eleonor de Ancitu. She says, thank you very much for that clarification. And if I can add something here, the WTO has recently argued that there is nothing in WTO rules or trade agreements that blocks states to take environmental measures. And this was particularly argued by the WTO Secretariat last week at the IDP meeting, which is the informal dialogue on plastic. So this seems to be highly concerning in light of what Professor Heath just said. Mm-hmm. And then we have one question in Spanish, and as I'm not fluent in Spanish, I allowed myself to use an automatic translator. So sorry if this is not entirely accurate, but freely translated, the question is, what would be the expert's recommendation regarding the wording of the treaties in order to avoid an extensive interpretation by an arbitral tribunal? And maybe to just add one further question right now, to what extent do you think that the decision could be annulled, since the obvious mistake with treaty exceptions and customary rules on circumstances precluded wrongfulness is very similar to the annulled Argentina cases? Yeah, so maybe those are the first questions to ask our panelists, and we can have a second round of questions afterwards.
Thank you very much, Lucas. And yes, please continue to put your comment, question, and reaction on the chat. I would like to just briefly mention that one of the questions related to how this kind of provision can be drafted in a different way to have a better impact, if possible. We will discuss it in the second part of the discussion. Exactly, we will have a look on that. So maybe Ben and Simon, you want to put your response to this question on hold as for now, because I will ask you a question about that. So, but yes, I let you maybe see if you want to respond to the question, over question, and I think it's actually only one question, but also you can reflect on comments as you wish, particularly the one regarding the WTO new decision. Maybe Ben, you want to go first and say something about what participants shared on the chat.
Yes, thank you very much for all this, and thank you. Sonia, I was looking for that study last night, so thank you for sharing it. I would emphasize with respect to the WTO, on which I have maybe less strongly held opinions. Again, when an environmental fails at the first step, an environmental measure fails at the first step, there's an opportunity to fix it, right? Which we don't have in the investment regime, and that is part of this sort of all or nothing thing that creates this problem. With respect to the possibilities for annulment, I mean, I have sort of, again, previously expressed my view that I think some of the reasons for annulment in previous cases apply a fortiori even more strongly here. I think we have a case where the application of the applicable law was incredibly confused. Many treaty provisions were simply ignored. And in addition, I can only understand the tribunal's reasoning on the exceptions by bringing to it what I know are fashionable arguments that claimants' lawyers make, right? So in other words, if I just try to sit down and read this opinion on the application of the exception from beginning to end, I cannot follow its reasoning from A to B. I cannot understand what they think the mechanism of the exception is. And I think that's a very clear grounds for annulment. Now, if I sort of step out of that box, right, and I sort of put myself in the ecosystem of claimants' lawyers and the kinds of arguments that they make, I can sort of see what these people are trying to do. Maybe I can infer and imagine, but I don't think that's enough to have an award that states reasons, to say like, oh, well, you can interpret this as long as you know what the most pro-claimant position out there is, and you can start trying to refigure your reading of this decision around that. That's not going to work, right? So here, I think we have a pretty clear failure to state reasons, especially there, also on other points, and the dissenting arbitrator brings up some other concerns. So I think there are quite significant possibilities for annulment here. I don't think that alleviates our broader concerns about the role of exceptions in these treaties, and whether they are reliable guarantors of flexibility.
Thank you very much, Ben. And your response made me thinking about the fact that in this decision, actually, we have two partial dissenting opinions. It also illustrates maybe some of the, when you say it, it's hard to follow the reasoning when you read the decision, sorry. Maybe Simon, to give you the opportunity also if you want to react on one point or not, or Ben already covered it.
He basically covered it, but maybe I can just add one thought on the question about annulment, which is, let's keep in mind the very, very low number of annulment decisions in the ICSID system. Experience shows that even when parties present apparently strong grounds for annulment, even in the CMS case that I had mentioned before, there's a tendency for ad hoc committees to say, well, there may be a mistake here. It may not be perfect. It might not be entirely clear. It might be wrong. In fact, it might be wrong, like the CMS ad hoc committee said, but I'm not going to annul because annulment requires this very high threshold. So, you know, again, I wouldn't count on an annulment, even though it's true that there are strong arguments, in particular on failure to state reasons and manifest excess of power. So that's the only thing I wanted to add.
Thank you very much, Simon. That's an excellent point to also to keep this in mind. And that reminded me that, as Ben said before, the second phase will be the calculation of the damages. And here I would like to take the opportunity to bring to the attention of the participant that damages is also, the way damages are calculated is also a big issue in international investment regime. And as ISD, we are producing a lot of publication, and we'll be happy to share them with you. And actually, part of the concern we are raising regarding damages can apply in the exact kind of this situation when there is this kind of reasoning, when there is this kind of environmental protection, legitimate protection aspect involved in the case. So this is also something to keep in mind, but this is not the subject of our discussion today, but I wanted to highlight that. I think we still have, let's say, a few minutes to take maybe one or two more questions before we move to the second part of the discussion. And I would like to ask Lucas if we have received a lot of comments. We can maybe take a few of them, and we can still also come back after the second part of the discussion.
Okay, we've actually received 3 questions. I don't know if we have the time to do all 3 of them, or would you want me to just pick?
Please share them, and we will see.
Okay, perfect. So the first question is by Samira Sulejmanovic. GATT exceptions are usually used in trade agreements. Could that be that having investments and trade in the same agreements, could that be problematic so that trade exceptions are totally differently interpreted in an investment policy context? And then Stuart True, have either of the panelists read Canada's 2021 Model BIT? And if so, are there comments on whether it might have produced a different outcome in Eco Oro? And then finally, a set of questions by EL. Does an environmental exception shield a state from liability for treatment that would otherwise breach the FET minimum standard merely by virtue of the measures being environmental in nature? In Eco Oro, isn't the point that the state's measures were implemented so arbitrarily as to destroy the value of the investment? Why should it matter that they are environmental measures? If they're implemented badly, why should the state not be liable for the damages it causes?
That's so excellent questions. I think it deserves to take time to try to discuss and address some of them. But let's say as brief as possible, Ben and Simon, and I'm also happy to come in if needed, but I think that's interesting questions. Maybe I don't know who would like to start maybe with the first question, and who would like to take care of the second question related to the Canada new bilateral investment treaty, which I found being a very interesting question here.
I'm happy to start. Oh, Simon, do you want to start?
Well, I was just going to say, I haven't looked at the new model FIPA. It seems to be have a bit of a different structure. I just pulled it up now. I'd be happy to hear Stuart's view as to what are the differences. Maybe he can educate us. I was just going to say, unless Ben has views as well, I was going to respond to the last question that was asked. Isn't this, I'm trying to pull it up now. Isn't the point that the state's measures were implemented so arbitrarily as to destroy the value of the investment? If they're implemented badly, why should the state not be liable for damage it causes? Okay, well, I think the answer to this goes back to the way in which the treaty was written. And I think Ben mentioned this earlier when dealing with the actual structure of the exceptions clause, which has some safeguards built in for arbitrary or unjustifiable discrimination. That's one of them. So you need discrimination that's either arbitrary or unjustifiable, or you need a disguised restriction on international trade or investment. So those are the safeguards. That was the agreement reached, that we don't want to overextend or expand the sort of exceptions to the exceptions that can be invoked. We want it to be very limited to these kinds of egregious types of conduct. And so that's the agreement of the party. That's how they structure the treaty, and maybe that should be respected. So that's my answer to that point. I'll let Ben comment.
Yes, just to follow up on that, I agree with everything Simon said. I think that here what you have is a tribunal that didn't go through the exception because it made a rather strange decision on the effect of the exception. But if the tribunal had gone to the exception, could it have found in these particular cases that there was arbitrary and unjustifiable discrimination? I don't think so, because the tribunal has said itself that there was no discrimination here. Could the tribunal have found that the measures were not necessary to protect the environment? Potentially, we won't know because the tribunal didn't do that analysis. But there are elements of the exception that the tribunal should have gone through to do this work. And the fact of the matter is it didn't do that. I think also in EL's question, there's entangling two things. One is whether an environmental measure destroys the value of an investment. It doesn't have to be arbitrary to do that. Another is whether an environmental is arbitrary. It doesn't have to destroy the value of an investment to do that. And the question is, what do we want a regime to protect against? And I think there are many people out there who want a regime to protect against environmental measures that make investment not valuable anymore, regardless of whether those measures are arbitrary. And you see that in some of the partial dissent by the claimant appointed arbitrator. And from my perspective, I don't think that's a worthy goal of the investment system or of international law generally. I think that states need to adapt to the changing environment and to climate change. And if they have to do that by damaging investments because some things are just not going to be possible in the future, then that's life, right? Because we all have to live on this planet, right? And so that's one question. Another question is whether they do it arbitrarily and how searching you want the review to be at the international level. And that's sort of a separate question in regime design. I agree with Simon. I think it's useful to talk about the 2021 Canadian model treaty. My impression from sort of doing a first read a few months ago is that they've pulled back on this rule exception framework a little bit. And so you don't have the same sort of general exceptions logic here. But there are also still questions. They've also changed the way they approach the minimum standard of treatment in ways that are sort of outside our scope, but are worth thinking about. It aligns a little bit more with the CETA in ways that I find troubling, but I'm just going to sort of park that. And then the third question, is it better to have to sort of separate these streams of trade and investment policymaking? I mean, I think so. Danny Roderick has an article called "What's in a Trade Agreement?" And it turns out a lot of it isn't trade stuff. And investment is one of the examples he offers alongside intellectual property rights protection. These are potentially rent-seeking pieces of trade agreements that business is looking for to get extra protection from political risk. And it's not clear that we should be giving it to them.
Thank you very much, Ben and Simon, for this great intervention and response. I mean, of course, participants can continue to discuss and comment on these responses. If I may, just on the last point you have raised, Ben, about investment chapter on the FTAs, I think it's also important from a negotiation perspective, and we have seen that in the past, to make sure that when you are negotiating such complex provision, you make sure you have people that are expert in the investment law field participating in the discussion, because otherwise you can have a risk with trade people, of course, with expertise in the trade, not realizing that maybe some concept and some provision cannot just be imported and put it in the investment chapter 1 without a careful examination. So thank you so much about that. And I would like now to open the second part of the discussion to make sure we have proper time to touch the remaining part of our discussion. And I would like now to over to Lucas and Nyaguti for making a presentation about some data regarding how, this kind of environmental exception in investment treaties, but also, and more importantly, put on the table some key consideration and questions to discuss about the future or the reform of investment treaty in the future based on the lesson learned from Eco Oro Decision. I would like to maybe ask kindly to my colleague Lisiane if she can start sharing the PowerPoint so everyone can see it, and over to you, Lucas and Nyaguti, for the presentation.
Thank you very much, Susie. So together with my colleague Nyaguti, we're now going to take you through some of the data on exceptions in investment treaties, as well as some of the policy questions that are arising out of the Eco Oro decision. So here you can see the environmental and health exception that was raised by Colombia in the Eco Oro case. And we can actually recognize the structure that Ben was talking about earlier. The language is almost a verbatim reproduction of Article 20 on general exceptions in the General Agreement on Trade, on Tariffs and Trade. And in the decision in Eco Oro, the tribunal accepted that the exception applied to Colombia's regulatory measures, but it held that this did not mean that there was no obligation on the part of Colombia to compensate Eco Oro for any losses that the application of the exception would have caused. As we will see, similar exceptions are a very frequent feature in international investment treaties. So this pie chart on the right-hand side shows the number of investment treaties containing environmental and health exceptions that are substantially similar to the exception raised in the Eco Oro arbitration. And we have looked at the data from the UNCTAD Investment Policy Hub here. So 241 out of 2,547 mapped investment treaties contain such an exception, which amounts to roughly 10% of all investment treaties that have been mapped on the UNCTAD database. They do not necessarily list all the items of the GATT Article 20 exception, but the exception itself is drafted in a similar way. Particularly, these exceptions typically include the language of the first part of the exception that we saw on the screen before. And usually they refer to non-discriminatory legal measures for the protection of human, animal, or plant life, health, or the environment, etc. While 10% of the treaties might seem low at a first glance, it is important to note that similar exceptions have mostly been included in more recent treaties, whereas the bulk of old style treaties do not contain such exceptions. So particularly in recent treaties, negotiators have gone further in defining and fleshing out the content and wording of these exceptions, including more specific and detailed list of what kind of conduct is part of the exception. In many cases, they have gone beyond the GATT Article 20, the content of GATT Article 20. And here you can see that a little over 50% of those treaties that contain such exceptions have offered more specific and fleshed out definitions. Even where the treaty language is more detailed, the vast majority of treaties, however, does not specify whether or not compensation is due for damages suffered as a consequence of regulatory measures that fall under the exception. However, this is to the notable exception of the recent Moroccan Model BIT that was published in 2019. Morocco's Model BIT actually contains a general exception that deals with the issue of compensation expressly. And my colleague Nyaguti will refer to that example in a moment. So besides the number of treaties containing exceptions similar to the GATT Article 20, it is interesting to look at the trend in treaty reforms to include such exception clauses over time. So the graph on this slide shows the annual number of treaties signed that contain a GATT-style public health and environmental exception. We can see a first peak in 2001 and a second one in 2014. But in a general sense, we can see that a significantly higher number of treaties include such exceptions in the last, or included such exceptions in the last 10 years than in the 2000s. This can be possibly understood as corresponding to states' overarching efforts to reform their investment treaties to safeguard regulatory space in particularly vital areas of public policy, such as the environment or public health. But of course, it might also backfire, as Ben has mentioned earlier. So, and this progression has to obviously also be understood in light of the fact that the overall number of treaty conclusions per year is reflected in this on this graph. So certain states have been particularly active in including environmental and public health exceptions that are that follow the GATT example. As you can see here, this type of exception is indeed very typical of Canada's investment treaties. In fact, the Canada-Colombia FTA that served as the legal basis of the Eco Oro arbitration is part of that trend. Besides Canada, states like Germany, Australia, Mauritius, and India have frequently included similar exceptions in their treaties. And it's interesting to note that this list contains both capital importing and capital exporting states. And it is also geographically diverse, showing that GATT-style exceptions are considered a key ingredient across a wide range of different states, to an extent that they can now be considered as a standard treaty provision. So let me now hand over to my colleague Nyaguti, who will address some of the policy questions and considerations that follow from these trends and the implications of the Eco Oro decision in general. Nyaguti, over to you.
Thanks, Lucas, for that great overview on the data and the treaty reform trends are related to environmental exceptions in investment agreements. So indeed, treaty drafting and treaty-based arbitration between investors and states has often gone to important issues of public policy, such as the state's right to regulate in various public interest areas. In such a context, the current system, while showing encouraging signs of evolution with the inclusion of exceptions, is still alarmingly inadequate, as our panelists have alluded to. Governments such as Colombia are today being legally challenged as they pursue more balanced investment policy frameworks. And as we know, the tribunal in this case decided that a general environmental exception in the FTA could not relieve Colombia from its obligation to pay damages. So some countries are proactively anticipating and aiming to address this challenge of exceptions being misinterpreted by arbitral tribunals. Morocco's new model BIT that Lucas mentioned has taken a very interesting and insightful approach and in addressing this issue. And it reads as follows under Article 21 of General Exceptions. Nothing in this agreement shall be construed to require a party to pay compensation by reason of the adoption of measures taken in good faith on a non-discriminatory basis and of general application to, and they go on to list a number of measures, including E, which reads, to protect and conserve the environment, including exhaustible natural resources, whether biological or non-biological. This is but one option of addressing this issue in trying to balance investment agreements to ensure that they grant their host states an additional and powerful safeguard to ensure public interest exceptions are not subject to compensation. However, this language is not, to our knowledge, included in any existing BIT. The Eco Oro decision prods the question on what are the immediate and longer-term treaty reform options available to countries. And actually, what does this mean for developing countries' efforts to reform existing and to negotiate new investment treaties? We wanted to draw out a few questions for considerations as countries embark on treaty reform options, both at the bilateral and at the multilateral level. So for starters, at the bilateral level, at the national level, countries are developing model BITs. And are countries considering the inclusion of such environmental exceptions in the new model BITs? And do you think that these exceptions will be sufficient in achieving the intended objectives of protecting public interest measures? Is there new language that reflects similar language to that of the Morocco model BIT? And will this still curb arbitral tribunals from interpreting these provisions in novel ways, as we've seen in the Eco Oro decision, and often in contrast to, and by all means unintended by the state parties to the treaty? Another issue is joint interpretation is one treaty reform approach taken by countries and relatedly relevant to the case at hand. In the Eco Oro decision, the tribunal outright disregarded Canada, here being the home state, and Colombia's detailed submissions, detailing the intentions when signing the BIT. But what does this say about the tribunal's discretion and the ISDS system as a whole? For those of us who are not familiar, joint interpretive statement is a written instrument developed and issued by parties together, clarifying one or several specific provisions without amending or renegotiating the treaty, and is usually seen as a more immediate approach to treaty reform, as they consider other longer-term approaches that I'll talk to just now. So do you think that a joint interpretive statement would be sufficient in addressing the issue at hand? Termination is another reform option being taken by countries, both capital exporting and capital importing. So two states can agree to terminate an investment treaty between themselves, or they could also decide to do so unilaterally. However, investment treaties typically also organize their survival after their termination, usually 10 to 15 years. Would this reform option be sufficient at addressing the issue at hand of ensuring states' right to regulate and protect public interest measures is a reality? Renegotiation is also an option to deal with countries' existing stock of BITs. And as mentioned earlier, the majority of the bids do not include such exceptions as that we've seen with Morocco. So there are treaty reform options at the multilateral level. And there's a general trend towards negotiating mega regional agreements. What can be done to address the challenge of ensuring carve-outs and exceptions included in these agreements meet the intended objectives? And can these mega regional agreements really address the problem at hand? As we're all aware, there are also ongoing reforms happening at ICSID, Ancestral Working Group 3, that most of us might be participating in on this call, related to the ISDS system. Are these reform processes sufficient to address the challenges posed relating to public interest exceptions in investment agreements? And what reform mechanisms do you think would help better address ISDS systematically? Whatever the category and the level of reform, there's a more fundamental and conceptual question. Are general exceptions the final and right tool for preserving states' right to regulate, for instance, when protecting the environment? Relatedly, should efforts be made on well-defining and limiting the scope of these provisions? Or does it make sense to add general exceptions to broader and unqualified obligations? In other terms, taking a positive approach in the investment agreements, which would mean you're entitled to do this, as opposed to a negative approach where you cannot do this except in this case. Also, given the tendency that arbitral tribunals think procedurally and state parties think substantively when they're drafting the investment chapters of FTAs or this bilateral investment treaties, what would be the issue with interpreting the treaty given the contrast between the two? Where should exceptions be included in the treaty, and how many exceptions overall should be included in the treaty? And should there be an exception to every provision? Also, should countries consider putting specific and tailored exceptions under each specific provision, as opposed to general exceptions on broad obligations? If general exceptions are still relevant, should they follow the GATT-style drafting, which is similar to the Colombia-Canada FTA, which is dated and designed for a very different system? And what could a new type of formulation be? Finally, the elephant in the room. Can general exceptions deliver on protecting government's right to regulate without a comprehensive and holistic reform of the IIA regime and ISDS? I'll now hand over to Susie, who will take us through the second segment of the webinar.
Thank you very much, Nyaguti and Lucas, for this excellent presentation on the data and the questions. And I think we are putting on the table a lot of questions, a lot of concern, which illustrate the fact that this is really a complex issue and a broader problem to think about. So during this next part of the discussion, and before we give the opportunity to the participant to reflect on some of the questions, some of the trend, make some suggestions and comments on how we can move forward in terms of treaty reform after this decision, I would like to give an opportunity to Ben and Simon to comment and reflect on some of the data shared, on some of the questions we have put on the table, if you have some views and comment more generally. But I have some specific more questions to you also. And I think we have seen in this presentation that the kind of general exception that was considered by the Eco Oro Arbitral Tribunal is included in most recent investment treaties, even if the bigger number of old-style BITs still not have this kind of exception, but just for recent one, we really have a trend to include this kind of exceptions, and they are really based on the GATT Article 20 slide. And we also said that the tribunal acknowledged that this kind of exception does not prevent the obligation to compensate. So I would like to ask to Ben first, in your opinion, is there really a safe, well-crafted treaty reform language that could emerge or currently exists here after the Eco Oro decision? We have shown, for example, the approach from the model, the Morocco new model BIT. Maybe this is something you are just discovering, but thinking about that and over example, maybe elsewhere or over approach you have in mind, do you think really there is a safe approach here in terms of drafting general exception in investment treaties for environmental legitimate measure that state can take? How
yes,
can
thank you. Yeah. Oh, yeah. Yeah. Thank you for that question. I mean, the answer is that investor-state dispute settlement is never safe. so there's nothing safe. There are, so if you're a policymaker, please take that back. But there are some low-hanging fruit things you can do that might help. So, one thing that you can easily do is, states can do what they always do, which is drop a footnote to address the award they don't like. So in the next treaty, you drop a footnote to the general exceptions clause that says, for greater certainty, if a tribunal finds that the exception applies, then there is no violation of the agreement, no state liability, and payment of compensation is not required. Right? The for greater certainty implies that this is always the case. We're just clarifying it because some of you didn't get it the first time, and we'll go forward. You can see like the 2012 US model bit is just littered with footnotes because they keep trying to pare back on bad rulings they don't like. The Morocco version is sort of a similar text to that. I mean, but just looking at that slide, it's a little different because it effectively gives up on the idea of breach and it moves to compensation. So it says payment of compensation will not be required, but it doesn't say anything about whether the measure breaches the treaty. So you could end up with an award that says the measure breached, but we can't award compensation, right? And so the question is, what other remedies are available, or how does this play out in a state-to-state dispute settlement context if that were to come up, and so forth, right? But it's slightly different. But the difference for the bottom line for many states might not be very strong between these two approaches. But if you have cooperative treaty partners, you can issue joint interpretations that say the same sort of thing, right? Or even treaty amendments to existing treaties. But I think states also need to be wise to what's happening here. So earlier, Susie, you mentioned Professor Wolfgang Alschner. One thing he said is that online is that he said, we used to talk about a backlash to investor-state arbitration from the states and the NGO community. And now, as we've seen resistance to these new style of approaches, maybe we need to talk about an arbitrator backlash to the reform, right? And so what we're seeing is some quite clear attempts by states to change the rules of the game. And we're seeing arbitrators trying not to play by those new rules, right? And the question is whether any amount of clarity or specificity or anything like that is going to change that basic reality of what's happening, or whether this is just going to keep going on. And that's especially true with the exceptions clauses. And I sort of go back to my point I began with, why should we expect that a provision that says measures have to be necessary, that closed list of valid policies, is going to lead to a more flexible treaty rather than a more closed one?
Thank you very much, Ben, for this question. I think it's really straight to the point that And this is, as Nyaguti said, maybe the elephant in the room. To what extent really we can make some piecemeal fix in an instrument that was designed at the first place not to deliver what we want to achieve today. So this is also maybe a bigger question to keep in mind, if we should not even at some stage completely rethink this kind of instrument and what we are looking for, what we would like to get from this kind of instrument at international level. But I now would like to turn to Simon to give you also the opportunity to react. And I mean, I would like to jump on the fact that most of these treaties, the old style treaties, actually do not integrate this kind of exception, as we have seen in the presentation. So could one say then that such treaties, these old style treaties, are silent on the issue? And what does it mean for a country, for example, defending a strategy in an arbitration based on such category of treaty? Because here, Colombia was able to rely on that kind of exception and it didn't work. But what about a country but trying to get a defense in a treaty but do not even have this kind of exception drafted inside? What can you say about that?
Right, thanks, Susie. And it's true, in investment arbitration, you often see claimants arguing that if the contracting states did not include exceptions or other express limits on claims in their treaties, then no such limits exist and the treaty should be interpreted expansively. So this kind of reasoning raises questions about the default assumptions of contracting states when entering into investment treaties. Can it be assumed that states intended to limit their ability to adopt environmental measures simply by including an FET clause or an expropriation provision? Not necessarily. Even without an express exceptions clause, states can argue that tribunals have to take into account the well-established freedom of states to regulate to protect the environment. For example, when it comes to assessing the existence of a breach of the FET standard, the inquiry often focuses, for better or worse, on the claimant's legitimate expectations. Can it really be argued that a claimant has a legitimate expectation that its investment will never be affected by regulations designed to protect the environment? In my view, that's not persuasive. Tribunal can and should take into account the environmental purpose of the measure when evaluating the existence of a breach of the standards of treatment in the treaty. And it must do so even when there's no express exceptions clause in the treaty.
Thank you very much, Simon, for this kind of clarification and understanding. And we hope that, unfortunately, if there is the case in the tribunal, that they will follow this kind of reasoning. Let's hope. So I had a last question for you both before we have a discussion, but it seems that we have a lot of interaction on the chat, which is great. And I would like to make sure we have time for you to respond or comment on what participants are sharing right now. So if you can briefly maybe respond to this last question regarding the implication in terms of global reform processes. Nyaguti has mentioned the Institutional Working Group 3, for example. Do you think that currently what is going on happening at the Institutional Working Group 3 reform on ISDS, the kind of option discussed in this fora would help to effectively address some of the concerns highlighted in this by this decision relating particularly to the arbitral tribunal decision making? Are you optimist, or do you think maybe these are also some concern regarding how the question are put there and how the discussion are going on?
Yeah, thank you very much for that question. And so, sort of to be brief, my overall impression of the multilateral reform efforts is that it follows the dynamics we see in this, like this impulse to add exceptions or footnotes to treaties by simply being more additive, trying to add new provisions that take care of old problems, right? And so if you talk to folks who are embedded in the reform process, they're going to tell you that some kind of centralization will help. A multilateral court or an appellate body can correct these errors and lead to more correct and consistent decisions. But that's also going to entrench a system that is committed to staging these pitched battles between the interest of an aggrieved investor on the one hand and the efforts of a state to resolve complex and protracted social problems on the other hand, right? And it's going to do that with a limited and confused set of substantive rules and the ham-handed remedy of retrospective compensation. So the good news is in these multilateral forums, you could ask for better. And that means that you need to look at mechanisms that put down, sort of the pens and take out your whiteout or your erasers and think about like, what can we use and what can we do in a multilateral process to pare back this system? You can start by asking that an option to withdraw from ISDS in a managed and controlled and lawful way is added to the menu of options under consideration at UNCITRAL. And then maybe we can talk about other things that we can delete multilaterally. Like, can we come up with a mechanism for deleting FET and MST provisions from these treaties? Then maybe let's move on to MFN and umbrella clauses and effective means provisions and non-impairment. Get them out, right? And then this is the only way the regime is actually going to be optimized if we start looking at the rules we wrote in 1980, 1976, and start maybe thinking about which ones do we want to keep for the 21st century. Right? That's the only way we're going to get through this.
Thank you very much, Ben. I cannot agree more with you, and particularly on the trend to always add more and more, and this trend also, to follow closely the arbitration award. They decided that, so I go quickly to change something in my model and try to respond to this one. I mean, of course, it's important, but I don't think it's a sustainable way to proceed with a long-term reform. Simon, also to you, your reaction regarding this process?
Sure. Briefly, and I, first of all, I totally agree with what you just said, Susie. It's not just additive, it's reactive. And by saying that it's reactive, it means that it's too late. The damage has been done in at least one case with potentially very significant consequences on the state's budget. So that's just a footnote to what you just said. Now coming back to UNCITRAL, the two main propositions for reform on the table are the appeals mechanism and the system of appointment of arbitrators, right? On the appeals mechanism, maybe I'll have more of a note of optimism than Ben, possibly. I don't think that introducing an appeals mechanism would hurt. An appeals mechanism, normally, you would think, based on comparisons with domestic law and other systems, will normally improve the quality of decision-making, right? The same may be true of the reform of appointment of arbitrators by the parties and institutions primarily. This system has come now under intense scrutiny in terms of the independence and impartiality of the arbitrators. So I think there is value in that reflection at UNCITRAL. That said, I don't think that reforming ISDS on its own will do the job. The problem is not just the dispute resolution system, it's also the treaties. I think the two have to go hand in hand. Otherwise, as many commentators have noted, that there's a risk that the new adjudicators will simply apply and entrench the law created by arbitrators under old generation treaties. And you cannot just fix a few old generation treaties. To be effective, the reform has to be comprehensive. Otherwise, you can just engage in treaty shopping, you can just invoke MFN clauses, which have been interpreted liberally to permit reliance on other standards of treatment in other treaties. So the question then becomes, can we effectively engage in comprehensive reform of investment treaties? Well, technically, yes, there are models for that, including the multilateral tax agreement put together by the OECD to reform the web of bilateral tax treaties or provide a framework for that reform. So that's the technique, international legal technique. But in practice, this is made very difficult by many factors, including the existence of the thousands of treaties, the many variations in the text of those treaties. They're more dissimilar than we think sometimes. The inertia of many states who have not experienced the sting of investment treaty claims and awards. The lobbying by what I would call the claimant side community and the expert side community and by the arbitrators sometimes to preserve the system as it is. There are names that come to mind, and I don't want to name names, but we can all think about some folks who are taking those positions. So despite those difficulties, I don't think the right strategy is to give up. I think it's important to continue to explore the feasibility and modalities of effective reform. We should also continue, as we're doing today, analyzing and denouncing the excesses of some of the arbitral decisions to avoid the outcomes reached in those decisions becoming mainstream.
Thank you very much, Simon, for this reflection that I also deeply agree with. I'm acknowledging that we have only less than 10 minutes left for the time allocated to this webinar, but I would like to acknowledge, and we are really honored to see the participation of Professor Sonaraja on this call. That's really a great pleasure. I don't know if I may, and if I can kindly, I mean, if you have to make an exception during this discussion, we said we won't give the floor for oral intervention, but I think we will really be glad to hear from you also, since you attended this webinar. Thank you so much. If you would like to react at some point here and say something to the participant before we try to take some few questions and comments and close the webinar. Professor Sonaraja, if you have the floor, if we can give him the floor. Thank you.
Well, thank you so much for this very unexpected pleasure, really. This is a decision that, of course, strikes a lot of people from the developing world rather badly, simply because of the fact that one thought that with the so-called balanced treaties, there could be a different interpretation that could have been given to a situation which really affected not only Colombia, but the rest of the world as well, because we are about to have an important global conference on climate change. And so in that context, the fact that something that so innately concerned the environment has been given short shrift by an arbitration tribunal is an alarming situation. Obviously, Colombia was greatly concerned with the project, and it would appear from all the documents that have been stated within the award itself that great and careful thought had been given to the framing of the legislation, to the judgments and administrative decisions that had been taken within Colombia. So it's in that context that this award strikes a blow in the face of developing countries and their ability to regulate matters of great importance to their public. And in this case, not only of great concern to the public, but a matter that was in the global interest, because this was a region that was of significance to global climate. So this simply means that this new approach that has been signaled, the so-called balanced approach, providing for defenses to liability, is in shambles because of the fact that three arbitrators, totally unconcerned with the situation, are able to make a pronouncement that clearly gives preference to the protection of the investor than to the protection of the environment and the public interests of the people of a state, as well as global interests. I mean, that's what's significant about this case, because global interests, not only Colombian interests, but the interests of the whole world was involved. So I think there has to be a rethinking of these balanced treaties. It would appear that given the combination of arbitrators, and that's what's important here, it's the combination of arbitrators that mattered rather than the wording of the treaties or the interests that were involved. So the defect is with the system, and one has to think of a better system than what we have now of investment treaties, given the fact that the attitudes on investment protection, prioritizing investment protection over matters like human rights, the environment, have become so entrenched in the minds of arbitrators and as well as within the existing system. Let me not go on with this. Thank you so very much to permit me to participate in this. Thank you so very much.
Thank you so very much. We are really honored to have you participating, and thank you for your very insightful and inspiring reflection on this case, and pointing really to the point of this is a global community interest. It's not only related to one single developing country interest. Thank you so much. Now we have only a few minutes left, and I think we have a lot of questions and comments on the chat. I'm afraid we want to really have enough time to cover everything at this stage, and we want to stick on time because to continue to benefit from the interpretation. So what I would like to do now is to give a chance to Lucas to, let's say, summarize the comment and question at this stage, and ask then to Ben and Simon to maybe select one key question or comment they want to react on before we slowly move on to the closing of this webinar. So Lucas, over to you.
Okay, thank you, Susie. So as per usual procedure, I'll start with the comments quickly and then mention some of the questions, as we won't have time to deal with all of them. So Ko Yung-tung said that in addition to providing for exceptions and no compensation, BITs should include obligations on investors to comply with national environmental, etc. laws, and provide for counterclaims in order to promote sustainable development in the international investment treaty regime. And Ko refers to the David Avon versus Costa Rica award in that regard. Then a second comment by Lina Lorenzoni Escobar. Colombia fares badly on sustainability in this regard, so in the wake of this decision as well. The Paramo is now flooded with illegal mining, and that was just mentioned as a side remark. We've also received a comment in French by Abdou El Azizi. Donc je vais maintenant parler en français. Merci à l'IISD d'organiser ce webinaire qui traite une question importante.
Thanks to IISD for organizing this webinar. Morocco has paid particular attention to this question in its new regime in order to prevent the extension of this clause, which must not be misinterpreted by the tribunals. Morocco has introduced certain restrictions also on the clauses concerning fair and equitable treatment, national domestic treatment, and concerning other clauses. So the idea is that no compensation will be paid for the measures taken by the host state which are in the public interest.
Questions. Sanya Reed-Smith asks whether panelists think that exceptions such as Article 29.1 of the CPTPP, excluding tobacco control measures from the scope of ISDS, or the Indonesia-Australia CEPA Article 14.25 exception for measures implemented to protect public health would be a better means to address such a situation. Then Georgia Sangiolo asks, would an Eco Oro type of reasoning be applicable to non-conforming measures aimed at safeguarding the public interest? Non-conforming measures usually are relevant at a different stage of the reasoning for tribunals. We've also received a question by Nevin Soliman. Are there non-investment considerations that play a role in tribunals' reasoning? Can it be that tribunals do not want to deviate much from the often sought arbitral consistency with past awards on such issues? And then one final question by Jamie Kneen and Rifat Parvez. To what extent would it be possible to insert requirements to exhaust national courts, recourse to national courts before invoking arbitration? And what about local alternative dispute settlement forums? So now hand over to the discussants to choose which.
Thank you so much, Lucas. We received so great comment and so great questions. It will be hard to select some of them. As for now, I will kindly ask the participant and also the translator if we can at least take, let's say, 5 more minutes at least as expected to make sure we respond to this great question and close the webinar properly. Sorry, thank you for your patience. And now I will turn off to Ben to see if you can select one or at least find a way to respond at once to a few of your questions, if you can.
Yeah,
really important questions.
Thank you so much. So the question on counterclaims and also Lena's comments, I think are things we can take together because they speak to the richness of these problems, these like problems that the government of Colombia is trying to address and is not addressing perfectly, right? And so Lena brings up the problem of illegal mining. Right, that's something that's mentioned in the decision in a few places in ways I have a hard time wrapping my brain around how it's legally relevant, right? So there's no argument here that, for example, the government is discriminating against foreign investors in favor of local illegal miners, right? That's not on the table. But at the same time, illegal mining is quite damaging, right? So like, while this delimitation process is stalled and while there's sort of a lack of stewardship in the area, there are illegal miners using things like mercury that are damaging the water supply, right? This is happening. And what does the tribunal make of this? It's not clear. From the investor's perspective, they say, look, the sad reality is if we don't go in there, then, and this area remains undeveloped, is going to continue to be subject to illegal mining, and that's going to be worse. And everybody knows that. And that may be true, but I don't know how that enters into a decision to award damages to an investor, right? And I don't know how a system of investment protection is the right way to strengthen this kind of governance. If we want an international supervisory mechanism with more teeth than we currently have on climate change and sustainability and biodiversity and clean water, let's go there. And let's devote all this energy that we're putting into building a stronger investment system and move it and do that, because I want that. Let's go there, right? And that's the same thing I want to say about counterclaims and also about an appellate mechanism. And this is, to be clear, an area where Simon and I think, differ. I think an appellate mechanism, I think counterclaims at the international level, I think all that sort of thing is just going to create more international litigation over investment protection, right? You're going to spend more money and more time litigating these cases. This case was filed in 2016. It's not done yet. And when it's done, if there were an appellate process, it could be appealed. And so it could be done by 2024. All the time, people are taking lawyers' fees, arbitrators are getting paid. Why don't we take that resource and do something else with it? And in the meantime, there is a place where investors can seek local remedies and be exposed to counterclaims under local law, and that's local courts. There's no contest here that it's possible that Eco Oro had a right to compensation under Colombian law for what was happening. That's not contested. And it chose not to pursue that right and instead pursue international arbitration. You have to ask why, right? And here, it could have pursued those local remedies. And why don't we just use that forum for investment protection and focus our efforts on building an international superstructure around something that actually matters?
Thank you so much, Ben. That's really excellent. And also we know that some of the countries are actually negotiating at the working group 3 are putting on the table the question of domestic local remedies and also the importance of the domestic system. So now I turn to Simon, and if you can make the effort to respond very briefly to this excellent response and maybe react to some of the things that Ben have shared.
Right, I think I'll just, Ben has addressed many of the questions that were in the chat. I'll address one of the other ones which concern by Sanya Reed-Smith, which concern the actual language that you can use and what's more effective, what isn't more effective. And I think it's a very interesting area where there are a lot of examples of different approaches, different treaty texts being imagined. But again, it's in this context of the reactive approach of the jurisprudence. And one of the examples that Sonia, if I may, has put in the chat is the security exception in some US FTAs that said that if a party invokes the exception, quote, the tribunal or panel hearing the matter shall find that the exception applies. Well, of course, that's a little tighter, right? In a way. It goes beyond even the sort of self-judging language it considers necessary that you see in security exceptions in some treaties. But it shows you the length to which states are going now, saying, I can't even say it considers necessary because maybe I'm going to be questioned on that. I cannot say necessary and with these other exceptions to the exceptions because, like Ben said, an adjudicator is going to go straight into an analysis of these exceptions to the exceptions, like the discrimination exception, and find discrimination. So I think this epitomizes the one of the problems, and I refer to this as sort of this legislative inflation, right? In treaty making, you add more, you react more. What's the where does it stop, right? So that's my reaction to that question, and it's also, I would say, dangerous with respect to the. Remember, we're talking about the tip of the iceberg here, the new generation treaties. There's the iceberg itself is the old generation treaties that are the object of, I don't know how many percents, maybe we have statistics, but I wouldn't be surprised if it was 80% of the overall litigation is under the old generation treaties, because claimants think they're broader, they're less limited, we can advance more adventurous interpretations of those treaties. And so what happens is that then you see when I litigate under these old generation treaties, I have the other side saying, well, but you see, states can do this. They can say, if I invoke the exception, then you shall find that the exception applies. They didn't do this in this treaty. That must mean that that's not the rule, right? Well, so you see that the new treaty practice poses a danger to the bulk of the investment treaty litigation in a way. So those are just things to keep in mind when you think about the paradigms that you want to promote in terms of exceptions in treaty making.
Thank you so much. Yes, I fully agree with you. And this reminds me what Ben said before, be careful when we are adding exception to say for greater certainty, we are just clarifying something. And yeah, but I agree with you. It's really concerning how whole style treaty are interpreted now based on the new reform, new language put in recent treaties. And I think, unfortunately, we don't have any time left to take more questions and comments, but I can see that we are receiving a lot of them, interesting ones. I hope we will have opportunity in the future, maybe to continue the discussion on all the fora and contacts. So feel free to reach us as IISD and our speakers if you want to continue the discussion. But we also have to keep in mind that behind all of this discussion and this decision, it's a matter for real people in the countries, real people on the ground suffering from some of the implication of this kind of decision. And it's also important to keep it in mind. So for my closing remark, I will just want very briefly to take the opportunity of the translation to turn into French now. And juste pour dire que nous avons eu une discussion très enrichissante aujourd'hui, il est impossible de résumer ce que nous avons discuté en quelques mots, mais nous pouvons au moins retenir quelques messages clés, à savoir que la première est que cette décision vraiment préoccupante et choquante à plus d'un titre constitue une nouvelle sonnette d'alarme sur la nécessité d'une réforme en profondeur et systémique du régime international des investissements et de l'arbitrage.
Alarm bell which shows us the need to reform the international investment law regime. This does not prevent us from continuing to reflect on short-term actions and solutions in order to try and limit this type of interpretation in the future. This type of decision and situation does not divert our attention from the necessity of working on a reform in the long term. I would now like to thank all the participants who have attended this webinar. I'd like to thank our two panelists, Ben and Simon. I'd also like to thank you all for your very interesting and enriching reflections. I would like to thank the whole of the IISD team, which has allowed this webinar to be organized. In particular, Nyaguti, Lucas, Sarah, Andrew and Lucas. It's a pleasure to have you all with us today. We hope you enjoy the rest of the day, and we look forward to seeing you again at a future webinar. Thank you.